Welcome to this broadcast of the Business Contracts Bootcamp presented to you by the Monster Craft Law Firm. This is attorney and business owner Charles Monster speaking. Today, I'm going to give you a very fast crash course on what you need to know about contracts before you sign on the dotted line or push accept on the computer. It's critical information that could save you thousands of dollars, but more than that, the aggravation which comes from a lawsuit. So you can put my comments in perspective. I've been a business lawyer for over 36 years and have handled contracts in excess of $1 billion. I'm the founder of the Monster Craft Law Firm, which has 8 offices throughout the state of Texas. As I have used in prior broadcasts, I'm going to distill my advice down to 3 points of a triangle, which I call the contract hot zones. The apex of the triangle is for toxic provisions, followed by specificity of the deal, and finally, remedies. Let's start at the apex of the triangle, which refers to language in a contract which will take your rights away, regardless of what the other party told you to get you to sign. In most instances, once you sign the agreement, if you didn't read the document, you are stuck. A standard provision in any contract is definitely toxic because it takes away anything the other party might have told you, even if in writing, from the enforceable agreement. It is at the end of almost all contracts, and it's called a merger clause by attorneys and law students. It's usually under the heading entire agreement. What it does is it bars any statement or representation made by the contracting party prior to the time you sign the agreement or at the same time. As an example, if you buy a car, the salesman might say that the warranty is extended for another 5 years because he wants you to buy the car that day and get his commission. He or she might even email you something to that effect. If it is not in the written agreement, you lose. Tough news, but that's the law. That is definitely a toxic provision. Here's another one, waiver clause. That may sound too technical to worry about, which is a big mistake. Waiver means that you're giving up your legal rights to the deal. Now that doesn't sound unimportant now, does it? I don't think so. Examples in a contract would be you're giving up your right to sue the other party for fraud or misrepresentation. As an example, let's say you sign on to a construction agreement to build your dream house, and the builder deliberately uses substandard materials to make money in violation of the agreement and literally pockets the money to buy a fancy car. If he represented that the materials were new and intended to use substandard materials, that is not only a violation or breach of the contract, but fraud. Unfortunately, if you sign an agreement which has a provision that waives or bars your right to sue for fraud, you're stuck under Texas law. As horrible as it sounds, the fraudster will get away with it. That's what toxic provisions do. So be aware, it's not esoteric. There are many more toxic provisions, but unfortunately, we have to move on. The second point on the triangle, literally and figuratively, causes most of the problems we see, which lead to disputes and litigation. Deal points. By this I mean the key terms of any deal which typically relate to the price, description of services to be rendered, and time frame for completion. Sounds simple, but not so in the real world of business. The problem is that the buyer or business owner has a clear understanding of the terms, but the expression of those points may be incomplete or worse, ambiguous. That could be deadly, as the written words govern. To avoid this problem, make absolutely certain that the terms are clear, with emphasis on the price, services, and time for completion. In my experience, the second and third elements are usually the most problematic, as the services to be rendered and date for completion are often incorrect or imprecise. As an example, if you're purchasing expensive cabinets for your new dream house, make sure that the agreement specifies what cabinets you are buying and the quality you anticipate, such as the wood and style. If that is not made clear, you can get a substandard product. If the details are not clear, you will likely lose if there is a battle in court with the builder, which often occurs. The same thing can happen over expensive items like the style and construction of a living room or even a master staircase and more. The date of completion is almost always a problem in most contracts, regardless of the service area. If you don't specify the actual date of completion and make that the item of intention, you will likely have serious problems. Happens all the time. And put in the phrase, quote, time is of the essence, close quote. Our final point on the triangle is called remedies. What that means is your rights to go after the other contracting party if he, she, or it defaults. This is another key area of problems for our clients. Although there are many toxic provisions, the one to watch out for is often called a limitation of damages. What that means is that your damages you can recover are limited to what you paid the other party in the contract. As an example, let's say you hire a web designer to put up a website to launch your new business for which you pay $2,000. The website is horrible, malfunctions, and you end up losing $100,000 in lost business, in addition to hiring a new developer for $10,000 to redo the bad work. If there is a provision which limits the recovery to the amount paid, you get a whopping $2,000 in damages. If that isn't toxic, what is? And that is our brief module for today on toxic contracts. And unfortunately, what I presented is just the tip of the iceberg. No surprise that we recommend that an experienced attorney review your contract before you sign on the dotted line or push accept. At Mastercraft, we're here to help you, and any one of our 8 offices across the state of Texas can assist you. This is Charles Monster speaking, and I wish you prosperity in all things. Thanks for spending time with me.